DUI. That's a case which in Illinois can be both misdemeanor and a felony. Misdemeanor is considered a case which is punishable up to 364 days in jail, whereas felony is a case which is punishable 1 year and up. DUI has 7 subsections under Illinois law, everything from A1 to A7. Does not mean that A1 is more important and A7 is less important. They're just different ways a law enforcement officer, a police officer, a state trooper can charge and arrest an individual for driving while under the influence of alcohol. Illinois law does not require an individual to be actually driving their vehicle in order to be charged with a DUI. You'd simply have to be in what's called an actual physical control of the vehicle. All that means is you can be parked on the side of the road, keys in your pocket, ignition turned off, and you can still be DUI. If you have been drinking and you fall asleep on the side of a road with engine turned off, if you have the ability to turn your vehicle on, police officer can charge you with a DUI. The differences between A1, A2, A3, and so on and so forth are what's in your system. If you have alcohol concentration in your blood or your breath above 0.08, it's an A1. If you refuse to provide any sort of chemical tests for blood, urine, or breath, you can be charged under A2 subsection, which simply means that your behavior and your inability to perform field sobriety tests is so poor that officer has made a decision that you are under the influence of alcohol without you submitting to any chemical tests. If you inhale glue, if you inhale aerosols, you can be charged under A3, drugs A4, combination of drugs, alcohol in A5. Finally, we have cannabis, A6 and A7. But that's a different topic that we're going to get into at a different time. In Illinois, first DUI is considered a Class A misdemeanor, for which supervision is an allowed sentence. Second DUI, regardless how many years have passed between the first and the second DUI will always be considered a second DUI, and you will be convicted of it. There is no more second chances, no more supervisions. You will receive a conviction. Once you're convicted of a DUI, a number of very grave consequences will follow. Conviction for a DUI will lead your license to go into status of revocation, whereas suspension will kick in on a first DUI should you receive supervision. It's a rather complex formula when it comes to suspension versus revocation. Once you receive notice from a police officer that your license will go into suspension, you only have 45 days to drive. On the 46th day, your license go into suspension status, and they will be suspended for a period either 6 months or 12 months. It all depends whether you were cooperating with law enforcement or not. If you cooperate and you provide a chemical test, a breath test, and that test results in illegal drugs found in your system or breath alcohol concentration above 0.08, which is a legal limit, your license will be suspended for 6 months. If you refuse to provide any sort of test, blood, urine, breath, your license will go into suspension for 1 year. That is a punishment for not cooperating with law enforcement. However, the less you cooperate, the less evidence law enforcement and state attorney's office has to actually prosecute you and find you guilty. Well, the state attorney's office will not be the ones finding you guilty, it will be the judge. But if the state attorney's office does not have enough evidence to prove that you're guilty of a DUI, after trial, judge will issue a verdict of not guilty. There's always several ways how to handle a DUI case. Everything from pleading somebody guilty to taking a case to trial. But there's also variations in the middle. Everything from negotiating a plea deal, which will not result in a conviction for a DUI. Case can be amended to reckless driving. Case can be amended to reflect a statute that will not result in suspension, extension, or revocation of your license. Just going to court and saying I do not need an attorney, I can handle it by myself, will not do anybody any justice. Because simply pleading guilty will carry tremendous weight years down the road. Anything from conviction to revocation or potential jail time. On a first-time DUI, going to jail is rather unusual. Courts understand individuals make mistakes, and absent exigent circumstances, aggravating factors, it's possible to get supervision on a first DUI, not on the second. Second DUI carries a lot of weight behind it. That's why it's crucial to call your attorney immediately after the arrest, so we can fight for your license, so we can fight for the documents, so we can fight for discovery. Look at what the police officers have done. Find mistakes, take it to hearing, take it to trial, and at the end of the day, make sure you walk away either with no criminal background or absolute minimum consequences that are allowed in your specific case.